A major Second Amendment victory today in Texas in federal court. A federal district court judge has just struck down effectively and enjoined through a preliminary injunction the ATF's application and enforcement of the new frame and receiver rule that they promulgated through regulations and not through congressional statutes. The court has just found that a major part of that law is illegal under the law. Specifically, it says that the manufacturer and seller of these gun part kits should not be subject to this rule because the ATF lacks the legal authority to do what they tried to do through this new frame and receiver regulation. We're going to talk about this real quick in just a second. Hey folks, I am Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, best-selling author, and member of the United States Supreme Court Bar. If you haven't subscribed to the Four Boxes Diner Second Amendment channel, please do so and show your love for the right to keep and bear arms. Great news, folks. We have a major win for the Second Amendment, although not specific to the Second Amendment, a win for gun owners and gun rights across America. Why? Because federal district court judge Reed O'Connor in the Northern District of Texas in Fort Worth just entered an order literally an hour or so ago holding that the ATF's new regulations involving their attempt to govern and restrict frames and receivers, as they've now defined it, is illegal and not allowed under federal law. Basically, Judge O'Connor said that the ATF's new regulation that just went into effect trying to redefine frames and receivers is illegal because they exceeded the scope of their statutory authority under the statutes that gives the authority for the ATF to do anything with respect to firearms in America. Let me explain real quickly. We all know that in 1968, you have the Gun Control Act that was enacted that says, among other things, that if you're going to go into the business of selling guns, you need to get a federal firearms license. And when you do a federal firearms license, you need to, if you're going to sell it to someone who's not a licensee or transfer it to someone not a licensee, you have to engage in a background check, which we now call today a NICS background check. That is well understood if you transfer a firearm. But what exactly is a firearm? Well, it's not what I think it is or what you think it is. It's what did Congress say it was? And what did Congress say a firearm was? Well, Congress had very specific language that they used to define what is a firearm for the purposes of federal law, which allows people to figure out whether or not they're selling firearms for profit. Because if you sell a coffee mug, that's not a firearm under the definition, so you don't have to become a federal firearms licensee. But if you sell firearms, then you have to get an FFL and you have to go through the whole process. So the definition of firearm is very important to figure out whether or not you should license and what laws apply to you. And the ATF knows this. So just recently, the ATF tried to expand the definition of firearms. So under the Gun Control Act of 1968, the Congress defined firearm as follows: any weapon, including a starter gun, which will be or is designed or may be readily converted to expel a projectile by action of an explosive. 2, a frame or receiver of such a weapon. 3, any firearm muffler or silencer or any destructive device. That's what Congress defined a firearm as. They defined a firearm in basically any four definition or any one of these four can be met, and then it becomes a firearm. Okay, in 1978, the court goes over all this. The ATF defines a firearm and a firearm receiver and receiver and a frame. You know, the general rule is, of course, that a frame is generally used as terminology to define the main part of a handgun where the part's attached to it, and a receiver is kind of the main part of a rifle or a long gun that the part's attached to it. I know it's very general, but you get the gist of it for the purposes of this discussion. Okay, so what happened in 1978 is the ATF defined a frame or receiver as that part of the firearm which provides housing for the hammer, bolt, or breech lock and firing mechanism, and which is usually threaded at its forward portion to receive the barrel. Okay, perfectly fine definition. That was the case until 2022. So, What happened in 2022? Well, the ATF came out with new regulations that define frame or receiver. Remember, the words frame or receiver are in the statute, right? They're in the statute. But what ATF did is in April 2022, they issued a proposed final regulation or final rule that redefined frame or receiver as something that was part of a frame or part of a receiver, so they could capture so-called ghost gun kits or gun part kits that many people who want to be allowed to make their own gun will purchase. So what happened, of course, is this is what the ATF did under the new rule. They decided to regulate partial frames and partial receivers, not frames or receivers, but partial frames and partial receivers, which means by definition, if something's a partial receiver, guess what? It's not a receiver. And if something's a partial frame, guess what? It's not a frame. And if something is a partial baseball, it's not a baseball. You get the point, right? Parts are not the same as the thing. All right? So let's continue on. So what did the ATF do this year? What they said was that going forward under their interpretation of the law and the definition of firearm under federal law, they said that the terms frame and receiver shall include, here's the key language that blew them up today, shall include a partially complete, disassembled, or non-functional frame or receiver, including a frame or receiver parts kit that is designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. Here's again the problem. Duh. Again, it's not hard. A receiver or a frame is different than a part of a receiver or a part of a frame. Because if they were the same, you wouldn't need to use the words part of, would you? Because they'd be different. Hello? Okay. So you get the point. Now, the court immediately saw on this. Judge O'Connor immediately saw this. So basically what he said was this. The judge said that because the ATF has modified the definition of firearm to include weapon parts kits, he said the ATF's new definition of firearms, which shall include a weapon parts kit that is designed to or may readily be assembled or completed or converted to expel a missile. That's the other thing he said they tried to get away with. So what did the judge do? Well, the judge goes through and discusses the different parties in the case, specifically the different plaintiffs. They point out there was 2 individual parties suing the federal government, a company called Tactical Machining LLC, and also the Firearms Policy Coalition, a nonprofit which we all know and we all love, that supports the Second Amendment and brings lawsuits on behalf of gun owners and the gun space. Okay, so that's important because it affects who the injunction ultimately applied to. All right, so with that set up, what did the court decide? The court decided that the new definition of frames and receivers that include the concept of component parts or parts of frames or receivers is not allowed under the law because Congress said you ATF have the authority to regulate frames and receivers for firearms, but you don't have the authority to regulate parts of frames or receivers or kits that allow you to make guns. You don't have that authority. And ATF just stole that authority out of thin air and says, we have it. But the court says, no, you do not under the law. Because if you look at the definitions of all these different terms by Congress did not want you to regulate parts because that's different than the full thing. So the court said specifically that parts that might become or may become receivers are, not receivers. I repeat, parts or component parts of receivers that might become receivers are not receivers. Duh. That's what the court found, which is the no-brainer decision. Why the ATF, I know why the ATF refused to do this because I'm sure their boss, Joe Biden, basically wanted them to do this. But the court immediately says, you can't do this. This is not allowed under federal law. So then the court goes on and goes through a series of discussions and points out, for example, that when Congress wanted to regulate something that was not lethal, that was not really a weapon, and have it fall within the definition of firearm, Congress would put it specifically into the definition. For example, the court says the word starter guns. Now, we know what starter guns are. It's at the start of a track meet. Somebody goes a bang and the race starts. So the fact that Congress put starter guns in the definition of firearms told the court something really important here. The court said it was very clear that the notion of firearm is it's a weapon. And when something that's not a weapon needs to be encompassed within the definition of firearm by virtue of what Congress wanted, they wrote it in. Specifically, he says, well, starter gun is not a weapon. And because it's not a weapon, Congress felt the need to actually write it in and name it. And unlike starter guns, what did Congress not do? What Congress did not do in the definition of firearms is write in like gun parts or parts of receivers or parts of frames. So the court says, obviously, if you want to regulate parts or component parts of frames and receivers, go back to Congress and get that statutory authority. But you, ATF, do not have that authority to make up the law on the fly like you just did. I just want to read a couple sentences from this court's opinion. I will, of course, as I always do, I'll put the opinion down below in the description. You can check it out there and read it yourself. But here's what the court specifically wrote. I think this is the key holding or the major part of the case. What the court wrote, Judge O'Connor wrote, is the final rule by the ATF did not merely update ATF's terminology. ATF added an entirely new section expanding its jurisdiction to include, quote, partially complete, disassembled, or non-functional frames or receivers. ATF now claims authority to regulate parts that are designed to or may readily be completed, assembled, restored, or otherwise converted to function as a frame or receiver. The parts must be clearly identifiable as an unfinished component part of a weapon. In deciding whether something is a partially complete frame or receiver, ATF may consider other materials such as molds, instructions, and marketing materials that are sold, distributed, or processed or possessed with the item or kit. So the bottom line is the court said that the final rule's redefinition of frame or receiver conflicts with the statute's plain language. The definition of firearm in the Gun Control Act does not cover all firearm parts. It covers specifically the frame or receiver of any such weapon that Congress defined as a firearm. And here's the key language of Judge O'Connor, the key language. That which may become a receiver is not itself a receiver. I repeat, that which may become a receiver is not itself a receiver. Hello, we know this, and so does the ATF, but ATF went forward and tried to get away with this, and it looks like one federal court has caught them and says, you cannot do this. The other critical part is very similar analysis by Judge O'Connor. He says that a weapon parts kit, and this is very important, a weapon parts kit is not a firearm. I repeat, a weapons part kit is not a firearm, because again, a part of something is not the same as the thing, unless Congress defines it such, and they didn't here. So the court goes on to say that ATF has no general authority to regulate weapons parts. I repeat, this is in the decision. You can read it down below. The ATF has no general authority to regulate weapons parts. They can regulate frames and receivers, but not parts of them. That's what this judge found by reading the statute. The court also goes on, I think this is the key theory that he really hammers home, is that under the federal law, the only firearm parts that fall under the ATF's purview, meaning their jurisdiction, are the frame or receiver of any such weapon that Congress has defined as a firearm. But the final rule promulgated last month or so by the ATF regulates weapons parts kits. Weapon parts kits, that is aggregation of weapons parts that are designed to or may readily be completed, assembled, restored, or otherwise converted to expel a projectile by the action of an explosion. Now, the statute covers any weapon that is designed to or may readily be converted to fire a projectile. But Congress's definition does not cover weapons parts. This is what the court said. We all understand this, and this is what the judge said. The Congress's definition does not cover weapon parts. Does not cover weapon parts or aggregation of weapon parts or aggregation, the combination of them, of weapon parts, regardless of whether the parts may be readily assembled into something that may, at that point, fire a projectile. So to summarize, again, I think there's three key takeaways from this decision from Judge O'Connor in federal court in Texas. The first is it shows that the ATF exceeded its authority by trying to regulate parts of receivers or parts of frames or parts of guns through gun kits. When the court says under the federal law, you don't have that authority. You have the authority to regulate firearms as defined by Congress, which includes frames and receivers, but you do not have the authority to regulate parts of frames or parts of receivers, and therefore you've overstepped your authority and you are now hereby enjoined with respect to the one company, that's Tactical Machining LLC. This law does not apply to Tactical Machining LLC. Now, the court did not enjoin the rest of it with respect to the individual plaintiffs of the Firearms Policy Coalition for reasons they basically said we don't feel like there's enough evidence there for the moment to show that they are impacted. I think that's essentially what the judge was getting at here, but he basically says with respect to the company in the business of selling these gun kits, apparently, then they can no longer be held to account under this new and unlawful regulatory scheme that the ATF just came up with. So that's good news. I think the second thing that's critical is that, of course, that this is showing that the ATF cannot limit consumer choice. The federal judge is obviously aware of the situation, saying, you're limiting the ability of Mark and others to be able to buy these gun kits if they want to make guns, because, of course, as we've talked about, if you don't have gun companies, you don't have guns. If you don't have gun part kit companies, you don't have gun part kits. I understand there's some creative people out there that can do all sorts of things on their own, but most people cannot. So I think that's very important to show that this federal judge was aware that, hey, the ATF overstepped its authority, and this was going to do, among other things, reduce consumer choice, which is clearly would happen if these regulations continue on. But right now, at least with respect to one of the plaintiffs, the regulations do not apply. And I think this really does illustrate the importance of trying to limit the authority of the executive branch and the president to be able to just do anything he wants with a pen and a phone, to quote Barack Obama. Joe Biden, if he wants to change the law, he should go to Congress and try to pass a change in the law. He should not try to just have the ATF go out there and make stuff up, pass regulations and pretend, those are just an extension of old laws, when what they really are is brand new laws, brand new statutes that never went through the legislative process of going through the House of Representatives or the United States Senate. So anyway, right now, a big win for the plaintiffs in this case. Again, the name of the case is Vanderstock versus Garland. Firearms Policy Coalition was a plaintiff. Tactical Machining LLC was a plaintiff, and two individuals. So again, a big win for the Second Amendment, even though it specifically deals with ATF authority. But again, as you know, what ATF can tax or regulate or harass, that basically gives them the power to destroy. And if they are able to harass gun companies and FFLs out of existence, well, that's bad for gun owners and the Second Amendment. Okay, I hope you learned something here today at the Four Boxes Diner. We have a lot of breaking news lately. Hope you learned something again, and we'll talk to you soon here at the Four Boxes Diner.
Table 2A.